Story 1. I took my ex to court because she had used my social security number to sign up for cable. I found out about it when she stopped paying for the service. She got herself into trouble by just being herself. We showed up to court, and I turned in the contract from the cable company, showing my social security number and her own name signed on the contract. She didn't even try to forge my signature. She signed her own name and tried to deny that she had any part in it. The judge criticized her, and it was satisfying. Story 2. Not someone else, but my clients screwed themselves. I'm handling a landlord-tenant case, and my client was facing eviction for non-payment. However, the client was withholding rent due to habitability issues in the apartment, such as no heat, high lead levels, and vermin. I thought this would be an easy win for me. I continually advised my client to ensure they didn't spend the money. Keep it but don't spend it. If you can show the judge you still have the money, it looks really good for you in terms of making the judge believe you're withholding for valid reasons. We get up in front of the judge. The landlord doesn't have an attorney, so I'm feeling optimistic. There's no way I can lose. I present my arguments and the landlord presents theirs. The judge asks my client if they still have the money. The client responds, "No, I spent it at the casino last week." Story 3. My wife is the lawyer. When children reach the age of majority, if they do not continue studying and start working, it is not necessary to pay alimony. My wife's client found a new lover, which unleashed the wrath of the ex-wife, who started asking for more alimony for her children. To win the case, it was necessary to prove that the children were working, but they could not get any proof of it. There was not much chance of winning, but they still went to court hoping that, with the interrogations, they could find information that would put them in evidence. On the day of the trial, the children did not go. Only the mother and her lawyer were present. Judge: "Madam, tell me why your children could not come." Mom: "They could not get permission at work." Judge: Lawyer: "Mom." Another few seconds of silence. Judge: "Well, that was fast." Story 4. I had a client who was trying to get away from an abusive ex and filed for a restraining order. He shows up to the final hearing and is making a big fuss about a truck that they bought during their marriage. He said it was just his, and she had no rights to it because their marriage was void. I asked him on cross-examination what he meant by that, and he said that he had already been married in another state when he married my client. He said that my client had no idea, but that it means their marriage is invalid and the truck was all his. Not only is that legally inaccurate, the transcript of the hearing was promptly turned over to the police, who were actively investigating him for bigamy. Oh, and the judge gave my client the truck along with a 2-year no-contact order. Story 5. A friend kept meticulous records of how much time his estranged wife spent with their daughter. He used a pink highlighter for Mom and a blue highlighter for himself. Mom went into arbitration demanding full custody, substantial child support, and the house. Dad presented 3 years' worth of year-long calendars. Mom had spent less than a full month with the child in those 3 years. Mom was not happy with the outcome. Story 6. I am a lawyer and witnessed someone incriminate himself. I work as a public servant in a criminal law judge's office, and since I have a law degree, I don't normally do administrative work, though I get to be with the judge in some of the hearings. Last month, we had a huge drug trafficking case involving 20 or more people. Months of investigation, undercover agents, videos, audio, the whole ordeal. The hearing lasted 3 days. Anyway, when it was time for one of the defendants to be on the stand so the prosecutor could read the charges he was accusing him of, he was pleading not guilty, as he very loudly stated throughout the majority of the hearing. This continued until my boss, the judge, told him to be quiet or he would be reprimanded, to which he replied, "What are you going to do? Arrest me?" Which, to be honest, was actually a bit amusing. The prosecutor, as part of the facts of his case, told him that he was being accused of selling, trafficking, and carrying a specific amount of drugs, with the base of his operation being his house, where he lived with his partner. Mind you, said partner wasn't even in the hearing, as she wasn't arrested or anything since there was nothing linking her to the case. He then said, "Wait, I was the one selling the drugs? She didn't do anything." His lawyer, a state-assigned public defender, facepalmed so hard it's actually recorded in the audio of the hearing. He still pleaded not guilty. Story 7. A witness for the plaintiff in a civil suit, who was a co-worker of the plaintiff, testified very strongly against the company and in favor of the plaintiff. I questioned her about bias toward the plaintiff, if they knew each other well, were friends, etc. She said they were just friendly co-workers, work friends at best. I pinned her to it. When I got a chance to cross-examine the plaintiff, she had no choice but to damage her witness's credibility because not only were they very close friends, but they had become sisters-in-law just a few years before. No, they did not have the same last name or anything, but I had done my homework. I still don't get why people want to fight small bias by destroying their credibility, but it happens more than you'd think. Story 8. I am being sparse on details here due to confidentiality, but I had a client who was accused of a very nasty sexual offense. He had an alibi. He was at work where he was the boss. He had an employee who could absolutely vouch for his being there. I talked to the employee, and the employee confirmed this. It gets closer to the trial, around the time when I need to send in an alibi notice, which is advance notice to the prosecution so that they can investigate the alibi and determine whether or not it is true. But I am being careful, so I call the employee up again. Turns out my client fired him in the interim, and so the employee quite candidly tells me, "Oh yeah, he was definitely at work." But that's not what I'll say in court. Forget that guy, he is going down. I did not call him as a witness or file the alibi notice. Still won the trial, but if I hadn't thought to call the guy, or if he'd been less candid, my client would have been in serious trouble. Sex offender registry, jail time, the works. Completely innocent. Story 9. Too many criminal client situations to count, with them screwing themselves over. One of the very few family law cases I handled as a young attorney stands out to me. A young woman and a young man have a child. The young woman seeks a divorce from the young man because he enjoys the thug life. He had recently been arrested and charged for possession with intent to distribute methamphetamine, a felony, and unlawful possession of a firearm. The young man doesn't like her leaving him, so he hires a well-known local top divorce attorney. Granted, it is a very rural area. A temporary divorce order is entered, stating she cannot have overnight guests of the opposite sex, common in rural conservative areas. I think it's mostly a thing of the past in more urban places. The young woman starts seeing someone new. The young man is very upset about this and has his fancy lawyer request a hearing, accusing her of violating the court order and seeking full custody, on top of attorney fees. The young woman, on advice from a mutual friend, hires me for this hearing. I sit down with opposing counsel, and she basically tries to strong-arm me with her experience, laying out egregious terms. The mother must not only give up primary custody, but also must have visitation with a supervisor and pay child support and attorney fees. She knows I'm a new attorney in town. I'm fairly certain I had been licensed for less than a year. I balk, and she says she'll see us in court. I go into the hearing with a copy of his probation arrangement on his possession with intent to sell and unlawful carry. He hasn't told his attorney about this, and she is unaware. She calls him up and establishes how my client had her new boyfriend over on certain nights. The judge is very conservative and not pleased. Then, opposing counsel passes the witness. I ask him if he has a job. No. What do you do for money? Things here and there. Oh, MS. Opposing counsel is awfully expensive. Do you sell meth? What? Have you ever sold drugs to make ends meet? Ooh, no. I introduce a copy of his guilty plea and straight probation sentencing. The judge is now staring daggers at him. I lean over to my client sitting next to me and whisper, "If you took a drug test today, be honest, would you be completely clean?" "Yes." I ask the young man, "When was the last time you did meth?" The attorney objects, but the judge overrules. I know this judge will drug test people on the spot, as he is also the misdemeanor drug court judge. It's been years. I'm clean. So, if you were tested, you'd be clean? Yes. Opposing counsel asks the same of my client, and we agree. The judge has them both tested. He tests positive for meth. My client is clean. The judge denies his motion and asks me to send in new temporary orders where the young man is required to maintain employment and start paying child support, and places him on supervised visits. Icing on the cake. Opposing counsel actually calls me and leaves me a voicemail congratulating me on, and I quote, handing her ass to her for the first time in a long time. Story 10. More of a case of screwing himself over, but here goes. This was a case another prosecutor in my office had a few years back. A 30-year-old defendant was charged with sexual assault of a child after he got his girlfriend's 14-year-old sister pregnant. She actually kept the baby, so the police just waited and got a paternity test. No surprise, the defendant was the father. The defendant wanted probation. The prosecutor refused to offer it. He decided to plead guilty and have a jury trial on punishment. Here in Texas, you can choose to have the jury set punishment. Evidence mostly proceeded as expected. The victim testified to having consensual, aside from not being old enough to consent, sex with the defendant, getting pregnant, and so on. Paternity test introduced. The defendant took the stand. His version of events was that he snuck into the victim's room at night, covered her mouth, and held her down while he forcibly had sex with her against her will. It seemed like his own lawyer had no idea that's the story he settled on. The jury deliberated about 15 minutes before returning a verdict of 17 years. The maximum possible as charged was 20. When interviewed by the attorneys afterward, one of them said they decided on 17 years so the defendant would never forget the age of consent in Texas again. Story 11. Not a lawyer, but this happened to me and some friends in college. A group of friends and I rented a 5-bedroom house in college. Being the group of guys we partied pretty hard and were really rough on the house. We knew from the start we were not getting our deposit back. Partway through living there, the septic system started to have some problems. Whenever someone used the downstairs shower, it would drain slowly filling as you used it. Also, the carpet in one of the rooms would get wet. We emailed the property service company to fix it. 2 weeks later, they sent out a plumber to snake the line and leave. That didn't fix it, so we emailed again. 2 to 3 weeks later, a plumber came to snake the line and left. Still not fixed, we emailed again. 2 to 3 weeks later, they scoped the line. It turned out roots had grown into the line, so they had to undertake a big process to completely remove all the roots. Now it was fixed. We all moved out and went our separate ways. One of my friends went to Australia for 9 months. When he got back, he found a bunch of voicemails. The property company was coming after us for about $5,000 on top of the deposit. They tried to pressure him into either paying the money or face court action. He told them he would see them in court. For the couple of months leading up to the court date, he received calls telling him to pay and it would all go away. The day before the first day of court, they called him and offered to settle for $2,000 if he provided contact information for one of the other people on the original lease. He refused and said, "See you in court." The first day of court was just to make sure everyone appeared and to schedule the actual case. The lawyer for the property company showed up, scrambling to figure out what was going on. They had no records beyond the original lease, which had changed a couple of times as people moved in and out. My friend helped him by providing copies of the multiple emails we had sent to get them to fix the septic system and the damage it did to the house. The lawyer told my friend he would let us know how they wanted to proceed. We never heard from the company again. Story 12. Someone I knew had a pro bono case where she had to defend a person who had been charged with a criminal offense. Even though the police and the district attorney could pretty much pinpoint the crime to her client, there was no evidence to tie him to the crime, circumstantial at best. She had instructed him to remain silent and let her do the talking during the trial, as from experience, the client sometimes does not know how to answer a question properly. She pleads and can show that the court has nothing on her client. She feels that for once, a pro bono case is going her way. After her plea, the judge thanks her for her plea and turns to her client. He asks if the client has something to add to the plea. The client looks at her, back at the judge, tears well up in his eyes, and he blurts out, "I'm so sorry. I'll never do it again." She threw her notes and everything else she had in her hands at the client, now convict, apparently. She basically got undermined by her own client, who undermined himself even worse. Story 13. Well, not my story, but a prior boss's story. They had a drunk driver kills a car worth of people case at the time when they were a general practitioner. My boss was representing the family that got hit, one where the 2 kids and the wife had died, but the father had not, and wanted the college guy's drunk driving repercussions to be severe. This was back before Facebook was commonly used in court proceedings and before many people realized that such evidence is too valuable for any attorney worth their weight in salt to pass up. So, the kid, a drunk driving college student, had managed to gain the judge's sympathy during the first part of the hearing by saying he was sorry, haunted, never going to drink again, and that this incident was going to ruin his life. The judge seemed to really be absorbing it. Then comes my boss and immediately shatters this kid's remorse by presenting numerous Facebook statuses and photos of him binge drinking, partying, and even joking about driving drunk from the date of the accident up until a night ago. The kid looked like he was being forced to swallow hot coals, and the judge was absolutely livid. Needless to say, the kid had to do way more than just apologize and be remorseful after that.